Hey, good Saturday afternoon. Carl Rominger here. 540-0580. 540-0580 is the talk line number. Do you have a legal question? Call in now. Joined here in studio by my brother, Kurt Rominger.
Hello, Harrisburg.
And he's down visiting, so he came along, wanted to see how a real radio station works, although he thinks he might have been in one once before in college. But he thinks he did a lot of things in college he can't remember. So
This is true.
540-0580, call in with your legal questions. And, of course, I kind of put out news. I wanted to do an emphasis on estate planning. Later in the show, Mark Virginus is going to be joining us. And during the bonus podcast edition, he and I are going to do 4 segments on estate planning and estate planning issues. So if you've got a question that involves estate planning from a legal standpoint or a financial standpoint, save those questions up for later in the show. At the end, we'll bring Mark on, and then we'll do a bonus podcast with Mark and I answering those questions for you. 540-0580. If you have a legal question, call in with it now. And, of course, throughout the week, you can go to weekendappointment.com. People are posting their legal questions there. I answer them as we go. And, of course, we've built up a lot of questions and a lot of answers. So if your neighbor's tree fell in your yard, your spouse left you, and you're not sure what to do in the middle of the week, you can go to weekendappointment.com and find the answer there. Or if you don't find the answer already there, you post it, and I'll answer it throughout the week. That's no charge to you. And, of course, as a registered member of Weekend Appointment, you're entitled to a free will, and all you have to do is fill out the free will form, send it back in, and we'll do that for you. And we've written quite a few of those, folks, so it's the real thing. You can meet with me, come into my office, we go over everything. If you need more than a simple will, I'll let you know. We also do something very important, advanced life care directives and powers of attorney called a living will. And if you don't have a living will, but you do have a will, make sure you get a living will. And again, that's something we can probably help you with. Go to weekendappointment.com. Talk line number here today is 540-0580. Mike, you're on WHP 580 with Carl Rominger. What's going on?
Yeah, I'm calling. I have a couple questions on how divorce works.
Okay.
And I'm married. I have 2 kids and stuff there, and it just seems like it's just escalating. Me and her just arguing and stuff there, and I was just wondering how's it work with the children.
Gotcha. Well, first, Mike, it's good that your wife and none of her friends listen to talk radio.
No.
Second of all, in all seriousness, though, with kids, I mean, divorce and custody are really 2 separate things, but, I mean, they can't be completely separated. If you leave the house or she leaves the house, obviously the house that the kids have been in for any length of time probably has somewhat of an advantage, if that makes sense. So I usually counsel people, if you're planning to leave or think you have to leave, that doesn't mean you're going to lose custody. But don't move 50 miles away, 100 miles away, because that's going to make it really hard for me to argue for a split custody situation or a primary custody situation if the kid's school district and place of primary residence would be moved a long distance.
Yeah. That's what she told me. She said, if I leave, that gives her an advantage. That's why she tells me, I'm not going nowhere. You leave.
The short answer is there's something about the house might give her a little bit of an advantage, but I don't really think it makes a difference as long as you have housing that's adequate where you go to. And whether you have that in the first month isn't really that important. It's whether on a permanent basis you have it. Okay. Number 2, I would make sure that I was actively involved with the kids in as many aspects of their lives as possible. Hopefully you already are.
Oh, yeah.
And if you can show some history of that, obviously the judge is going to be interested in that. But the modern trend is towards split custody. In fact, there's movement to have legislation put in place where split custody would be the norm rather than or the presumption from the beginning.
Okay. Another thing, do the kids' ages have anything to do with that? Can the kids say where they want to be?
Yeah, good question, Mike. Let me just remind callers, 540-0580, 540-0580. 0580. Call in with your question right now, and we'll answer it after Mike's here. Now, Mike, age of the kids in a custody matter. Some states have a magic age. At 14, a kid can decide this. At 16, a kid can decide that. There's actually statutes to that effect. Pennsylvania has no magic age. Instead, the courts simply give weight to the child's testimony in accordance with their age. So an 8-year-old might have something very important to say in a custody case. It might be directly relevant. The judge may decide the case based on what the 8-year-old says. But more often than not, the judge is going to expect that a child of older years would carry more weight and more say. And so if a 17-year-old says, no way, no how do I want to stay with my dad, I want to be with my mom, judge is probably going to say, well, you're still going to have to see your dad, but I'll primarily put you with your mom.
Yeah.
So if that makes sense, also the reasons. I mean, sometimes kids are smart, but sometimes they give away more than they realize. And if you talk to them long enough back in the judge's chambers, I sometimes have seen kids reveal that, they really want to live at mom's, but then you find out that, well, mom's place is fun. She serves them chocolate cake kind of deal.
Yeah.
So the judge kind of goes, I know why they want to be a mom. Mom has no rules, so I'm not going to put a lot of weight on that.
Okay, yeah. I was just wondering there because we could argue and so she'll say, I'll say, well, leave. Say, good leave. That's what give me an advantage against you then and stuff there. It's just not good for the kids.
Well, and if you're arguing a lot, and I firmly believe this, if a couple is not getting along and they are arguing and fighting a lot, it's not healthy for the kids or them. And you're better off to leave and move on and get the kids out of that toxic situation. So I know that somebody out there is going to be like, no, you must stay married for the kids. Well, that doesn't really work. Trust me, if you're on the sofa and mom's in the bedroom every night for the last 2 years, the kids know it's not a happy marriage.
Exactly, yeah. That's about the size of it, yeah.
Yeah.
Okay.
All right.
I appreciate it. How can I get hold of your law office?
Yeah, if you go to weekendappointment.com, I've got my phone number plastered all over it.
Okay, I really appreciate it.
Yeah, and you can also email me from there. All right, Mike?
Weekend appointment, okay. All right, I really appreciate your time. Thank you.
Hey, no problem. Be happy to help you.
Thank you. Bye-bye.
540-0580. Call in with your legal questions. I'm Carl Rominger, if you don't know me. If you just crawled out from under a rock and this is your first time listening, because obviously everybody in the mid-state has heard this show by now, right, Shane? Isn't that what the numbers told us? They canceled Penn State off this station because of us, right? Isn't that true? No? It's not true? Okay, it's not true. I thought Penn State football got canceled just to make room for this show. Or is it Clear Channel's bankrupt? Oh, I'm sorry. Oh, they can't. All right, forgot. I'm mad because they got rid of their fancy coffee pot, so I just assume they have no money anymore around here. All right, 540-0580. Call in with your questions. I'll see you guys after the break. I like the music, Shane. What? I can't let the music play? Oh, man. He is so angry. 540-05... Oh, he really is angry now. 540-0580. 540-0580. Someday, you got to come down to the studio, folks, and meet Shane. He's an angry, angry man. Ron, you're on WHP 580.
Hello.
Hi, Ron. What's going on?
Hey, not much. Hey, listen, I got a ticket about going on not quite 4 years ago down in Philadelphia for... in a commercial vehicle following too close. It was in traffic and stuff, but I wasn't really concerned about it because I've gone basically free until now, but the company I was working for closed up on Friday.
Uh-huh.
So now I've got to go put some applications, and I put a couple in, but they're all squawking about that following too close. So my question to you is there any way that can be removed by departmental hearing over in Harrisburg?
The answer is no. That stays on your driver's record, I believe, indefinitely.
Okay.
Now, you can get it expunged if more than 5 years have passed from your criminal record, and I don't know if that would remove it from your PennDOT record or not. My suspicion is it wouldn't because the guys over at PennDOT just love to hang on to everything forever.
Yes, I know.
But you could at least get it off the criminal record. But whether it would stay on your driver's record after an expungement, I don't know, but my suspicion is yes. I don't think the statute speaks to that. Although, you know what? If it's expunged, I think we could try to get an order that it be removed from their records as well. But you got to go 5 years without any new tickets or crimes.
I never had no crimes. It was just this damn ticket hanging on there.
Yeah, I know. And, of course, this is something I always counsel people on. They'll say, well, you know what, I got steady employment, I'm happy with everything, I'm just going to plead guilty to this speeding ticket or plead guilty to this following too closely or this equipment violation or whatever. And they hang around, and then just like you're experiencing, 4, 5, 10 years later, it still haunts you.
Yeah, yep.
So the short answer is I don't think there's any great remedy for you.
Okay.
All right?
All right, thank you very much for your time.
Another year or two, Ron, and then we can get it. Then we can get it expunged, and then we'll try to make PennDOT get rid of it. All right?
Okay, that'll work.
All right, brother.
All right, thank you.
540-0580. Roosevelt.
Hey, Carl, how you doing, man?
Good, man. What's going on?
On a normal day, if I wanted to play around with you, I'd talk about immigration in case Bob was listening. but anyway, thinking of Bob, on one of his shows, I caught a little piece where you was talking about legislation that they are passing about what to do if an intruder breaks in your home with your firearm. And I remember you was talking something about that, what to do according to the new legislation if they do break into your home and you shoot them, and also something about what to do if you're carrying a weapon on the street and you have an encounter, what to do.
Yeah, this
Can you
is
elaborate that?
This is the PA House Bill number 40, which they are reported out of committee on the Castle Doctrine and self-defense. And actually, I have the last printed version of it up on weekendappointment.com on the front. It's the second article down, so you can see the actual text of it. But basically, it says, it's the right to stand your ground in public, and if somebody's attacking you or otherwise breaks into your home, you get the presumption that deadly force was necessary. It used to be you had to first prove that you reasonably thought deadly force was necessary, but now you get the presumption that deadly force was necessary.
Okay, you think it's a good bill? You have a good chance of passing?
Yeah, I hope it does. You know, the answer is it's not pro-gun or anti-gun, so I'm not sure why the gun folks, the anti-gun folks would have a problem with it, except it does include a provision that clarifies that if I have a handgun or another gun in my car and I don't have the bullets near it, but I have them stored in a separate container or compartment, that it's not going to be considered loaded, which is helpful because some officers have hassled folks saying, you've got bullets and a gun and they're so close to each other that I think you essentially are possessing a loaded firearm. And here the legislature is going to define it so that it's clear that it's not loaded as long as the bullets are still in their box.
I think that's a good provision. I don't know why anybody would be against that either, but okay.
Well, common sense, Roosevelt, but that's the problem, right?
There you go. All right, have a good weekend.
Hey, you too. Thanks for listening, by the way.
Okay.
All right, take care. 540-0580, Carl Rominger here answering your legal questions. I'm an attorney here in the Mid-State. If it's your first time with the show, make sure you go to weekendappointment.com, become a registered user. And remember, later this afternoon, Mark Virginis is going to join us. Mark is my financial guru. He's a financial planner. He kind of helps people with investments, life insurance, any kind of financial vehicle or issue that you would need. He and I are not CPAs, so we don't do the tax thing per se, although we're aware of some of that stuff. I do the docs. He does the financial end. So we're going to be looking for you towards the end of the hour here and then through the bonus hour to call in with your wills and estates type questions. Fred, you're on WHP 580 with Carl Rominger. Hey, Fred.
Hello.
What's going on?
I have a question about credit cards.
Okay.
If you have I have a good relationship with my spouse and everything, but she has opened some cards in her name and ran them up, and I didn't know about them until 5 months later, and she had not been making any payments.
Right.
Now, at this point, nothing has been paid since, I think, August of last year.
You are not personally liable for those, okay? And if she were to go bankrupt or if she's destroyed her own credit, that shouldn't affect you. However, the debt is marital debt because it was incurred during the course of the marriage, so It could be distributed in a divorce between the two of you.
Okay, even though my name is not involved,
right,
initiating it.
And I always point this out to folks when you're in a marriage and you title a car only in your name when you buy it, and she titles the house only in her name, and she gets a credit card only in her name. We don't care who it's titled to individually as long as it was acquired during the marriage. Now, you could argue to the judge that there's some fault, that in other words, she created these debts solely for her own purposes. It didn't go to marital bills. It didn't go to marital anything. You saw no benefit of it. And the judge might say, well, I'm not going to saddle you with all of it. But the theory is marriage is a contract, and you get your spouse's good and bad.
Okay, and I had one other additional question on the subject. Can your spouse open a credit card in your name, and especially after doing something like that?
No.
And how that would look out?
No, they can't use your name or open something in your name. That would be a fraud because they don't have your authorization to sign your signature.
Okay, I thought I had heard that somewhere before that they a spouse can.
No, they could put you on as an authorized user, but your legal rights vis-a-vis the credit card company are still the same whether you're married to somebody else or not.
Okay, great.
All right?
Thank you very much.
All right. Hey, thank you. Take care, brother.
See ya.
540-0580. Bill, you're on WHP 580 with Carl Rominger. Bill.
Carl?
Yeah, what's going on?
Hey, Carl, you're doing great. I pulled your website up, and on the right-hand side was this lawyer talking in like a classroom, and he was saying, don't don't tell the police anything, and if they say like, will Jesus forgive you for killing that person? And you said yes, then they might convict you. Okay, that's on the right side of that. I saw yours on the left side where you got pulled over and you did some talking to the cop, and you're smart and you can do that with a cop. My question is, should if I get pulled over and the cop says, get out of the car, where have you been? And I say, well, I don't even know. And he says, where are you going? And I say, I don't even know because I'm drunk. Should I not tell the cop anything other than just give him my license or cooperate?
My advice usually is, and obviously every situation's different, let me caveat it, and there might be times when being very friendly and helpful will, resolve everything without a criminal charge resulting whereas being a jerk, as I probably am sometimes, is going to get you in more trouble. Nonetheless, if you pay careful attention to my video, it's hard to hear what I'm saying, but I'm actually invoking my rights in the beginning, saying, I'm not going to answer your question. I'm going to invoke my Fifth Amendment right. I'm going to invoke my Fifth Amendment right. I want my lawyer, when he kept asking me questions after I told him I wanted to remain silent. And that's when they really... What's that?
Yeah. I didn't know that. We couldn't hear it.
Yeah, and that's so that I'm really not engaging them. And the answer is that's your best route. Let me put it this way: if I'm pulled over, and that particular evening, as I posted in there, if you read the comments, I really hadn't had enough to drink to affect a guy of my tiny size. Okay,
right.
But so I was probably just being a jerk, as some people would point out. On the other hand, if I knew I was butt wasted and 3 sheets to the wind, and heaven forbid I actually drove, no, I'm not going to answer any questions about how much I drank or if I drank at all or where I'm going or where I'm coming from. It's the government's job to prove me guilty beyond a reasonable doubt, and I'm certainly not going to do anything to help them, whether I'm guilty or innocent.
Great. Appreciate you. Thanks a lot.
All right, man. Thanks. Folks, he's referring to the videos. I've got these up on weekendappointment.com. If you want to see a real live DUI stop, the police stopped me for speeding one night, and they decide to make it into a DUI fishing expedition. You can see how that all breaks down. You can waste about 19 minutes of your life watching it if you want. The video you should probably also watch, or probably would be better spent watching, is the other one I've posted, which I took off of YouTube, which is a law school professor and a police officer on why you should never talk to the police. And you're going to if you listen to it, you'll be surprised, but they actually quote a Supreme Court justice as saying, United States Supreme Court saying, only an idiot talks to the police. So you'll be surprised if you pay attention to it why you should never talk to police. And one of the great ones that I always bring up to folks is what you say that can be used against you is admissible hearsay in court. What you say that benefits you, the things that tend to prove your innocence, are inadmissible hearsay. And so if your story tends to prove your innocence and you tell it to the police, it's still not going to make it into court through the police officer. Anything you say that could incriminate you will. So there's no benefit to telling your story to the police officer if it's going to turn into a court case. Let's see here. 540-0580. Jay, you're on WHP 580.
Yeah, Carl, I just wanted to clarify something you said before to a gentleman. I thought you said, and I wanted to... Are you saying if credit is open in one person's name, the other person doesn't know anything about it? Or you're saying, although if the debt was incurred during marital period, that the other marital party is responsible?
Yes, it's still marital debt. Now, I've had these cases, and what some judges will do is some judges might say, okay, I find that this was secreted and done, and I'm going to go ahead and just push that debt just to the one party. Discretionary with the court. A lot of other judges will say, listen, man, your wife was buying new clothes for the last 3 years. You didn't know it. You didn't look in the closet. You weren't aware of it. You know what? I don't believe it. So, you're both going to pay it, or I'll find some fault in it, but I'm not gonna make her pay the whole thing back.
Okay.
Yeah.
Now, what about? And they were talking about credit card companies too.
The credit card companies, your relationship with the credit card companies one-on-one. Now,
that's what I was thinking of. I don't know what the other debt the gentleman was referring to was.
yeah, he was referring to the concept of could your spouse sign you up for something and put your name on it?
No, I wouldn't. That's
They can't.
I'm
do
concerned. I mean, here's the situation is, let's say I have left my wife a lot of insurance, and tell her afterwards that's what I'd like part of it to go to, although she's not obligated, I suppose, because insurance is not like my estate.
That's correct.
I'm sure she would, although I think in some cases they probably have insurance with the credit. I mean, what generally happens, obviously, if you don't have an estate other than a house and
right.
car, things like that, which I don't really, nothing.
If you pass away with some debt, theoretically, spouses are responsible for the other spouse's debt in an estate situation. Theoretically,
in an estate situation.
In my experience, the credit card company will not go after the spouse.
Well, as I said, I'm hoping that the insurance she'll use the insurance to pay off, and I think she will. But in terms of tangible estate, other than that, I really don't have anything. Look at the house or something.
I had a relative that passed away one time. I remember the other relative being distraught that there was a lot of debt, and I remember saying, listen, you're not responsible for your relative's debt. And I find that in my practice, a lot of folks think that they're going to be responsible, like for their brother's debt or something.
Yeah, well, that's a different. I mean, as opposed to a spousal.
Yeah, and even though in Pennsylvania actually has a theory that parents and kids could be responsible for each other's debts, and there's a statute to that effect. Although it's in the process of being repealed, and I've rarely seen it used, but recently I did see a nursing home trying to use it to collect from somebody.
Well, because a lot of people morally think ethically, and I understand that. I certainly am not trying to put one over any,
right.
creditor, but I certainly don't want the other person burdened who really. It
is funny something you said though. You don't want to put one over on the creditor. And that's noble of you not to do that.
Well, it's wrong to do.
But what's funny is, if on the other hand, if you were to say, hey, what tax strategies can I develop to not pay the government, we would all say, yeah, how do you do that?
Well, you know what? I have a problem. My mother was on Medicaid for some years before she passed away. She was in a nursing home. And she had sold her house some years before that. But a couple of years, maybe 5 years before, there was still some money left, and it was in joint. We had made a joint checking account and all that good stuff. And I did use that money towards her, call it your upkeep or whatever you want to call it. But I know there are a lot of people that feel that they should be able to leave everything to their children. In my view, if you have assets, you shouldn't expect the government to fund.
Yeah.
That's what those assets should go to. The hell with the kids. I see people bankrupting themselves so the kids can go to college. There's nothing wrong if you can send your kids to college. That's great. I had to pay my way through.
Right. And Jay, let me tell you, I mean, there are certainly, and that's what we're going to talk about in the bonus hour, strategies that you can do to push wealth down the hill. But ideally, what Mark and I are going to talk about is how to do that, and at the same time make sure that you're not completely dependent upon Medicaid, because they don't exactly pay for the best nursing care either.
My theory is, why should the rest of us or the other, have to pay for people that have?
Right. Well, that's why we have look-back provisions and things. But nonetheless, like I say, we're kind of joking, but I'm going to help you out, and I'm going to tell people how you can kind of sidestep some of that later. Yeah, but it all has 5-year look-back provisions, so you have to do it well ahead of time. But trust me, this is...
well, I understand all that. I'm just saying to me it seems...
I understand. Yeah, that's why I say it's interesting. Most people are fine with getting away with putting one over on the government as to opposed to putting one over on a creditor.
That's true, yeah.
It's interesting. Okay. All right, Jay, I got to let you go because Shane's smacking at the window about a break here.
All right, bye.
540-0580. Hey, welcome back. Carl Rominger here. 540-0580 is the talk line number. And a little later this hour, I'm going to be joined by Mark Virginis, and we're going to do in our bonus hour some estate planning, wills and trust type issues. So get your calls lined up. We're going to leave the phones open. I'll be off the air at 3 o'clock, but we're going to leave the phones open from about 3 to almost 4 o'clock for you to call in with those questions and ask us. as we present that, and it's going to be up almost shortly after that as a bonus podcast, which you can get at WHP580.com or weekendappointment.com. And what else did I want to tell you guys? Well, if you're a friend of mine on Facebook, from time to time I'll post what I think I find an interesting news article with legal topics, so make sure you join me on Facebook as well. Ohio Supreme Court has ruled that police officers' visual estimate of speed is enough for a speeding ticket. And what happened was the radar results were thrown out, but the court went on to say that the officer's training was sufficient for him to determine how fast you were going, even though his speed was very different than what the radar gave, which had been thrown out, which makes no sense, but welcome to the law. Bill, you're on WHP 580. Hey, Bill.
Hello. Thank you for taking my call.
My pleasure.
It has to do with a township manager.
Yeah.
I came home about a year ago, and there was a township road truck on the small road truck, 1-ton road truck on the in front of the house, and I went in onto my property, and there was a woman from the codes inspection office, enforcement office, and this large guy that was obviously a road guy, non-uniformed or anything.
Okay.
And they were going around my property, and they said I had weeds. They said I had a truck with no license, and and they had a camera and started taking pictures, and I immediately ordered them off. The fella, he didn't make any say anything, but she started getting mouthy, telling us that she had a right to be on there, and I said, "Where's your warrant?" She says, "I don't have any." And then I said, "Get off the property. I'm ordering you off right now."
Right.
And she still continued to do it, move around. Now, does she have a right to get on there, or do I have a right to order her off?
You have the right to exclude her from the property. I wouldn't advise using force, however.
No, but I can use as mouthy as I can be, can't I?
Yeah, I think you would certainly be entitled to do that. The other thing, though, is that she can simply go back and get the warrant, and the warrant will be given the matter of administrative course. So it shouldn't be any problem for them to get the warrant. But once they have the warrant, then you can't do anything about it.
Oh, no, but it doesn't. Isn't she supposed? As soon as I tell her to leave the property,
she should leave right away.
She can't just be there.
She doesn't have a right. No, she just does not have a right just to stand around on your property as a general rule.
Right. Well, do I have a right to sue the township then?
What were your damages? Got to have damage. You got to have a wrong and damages.
Well, a few days later, I got a note from the township, and they said I was in violation of the weeds and everything else. And
yeah, but those aren't your damages. She probably could have made that observation from the road, right?
Well, I don't know. She had a camera.
But those aren't damages. That's something you were responsible for. You either were or weren't responsible for. I mean, what are your damages? A trespass has to result damage to be actionable in a way that you're not going to get more than $1.
What if I gently took the camera away and smashed it?
That would be illegal. You can't destroy property.
Even though I told her to leave?
Even though you told her to leave, you cannot do that. Bill, you're not allowed to breach the peace, buddy.
What's that?
You're not allowed to breach the peace. Neither are they, but neither are you.
But I'm
two wrongs don't make a right, okay?
No, but I'm a right to verbally abuse her, right?
Well, within reason, I think you have a right to ask her to leave. I think that's about as far as you go. All right, Bill, I can tell where this is headed. I'm going to let you go here. 540-0580. Bill, no offense, buddy, but they're going to come back. Just cut the weeds, move the car, whatever you need to do.
Maybe put a fence around them and call it a garden.
Yeah, there you go. I like that. See, there you go. There's practical advice. I got legal advice. My brother's got practical advice. David, you're on WHP 580. David.
Yes. Hello, Carl. Recently, the Supreme Court scaled back the Miranda rights. I was wondering, what your understanding of that decision. From what I understand is that, once you talk to the police now, you've pretty much waived your right to the Miranda rights, and you have to firmly state that you want to remain silent and request a lawyer?
Yeah. What was interesting was, okay, in that case, the guy basically didn't talk. And didn't answer any questions. And like 3 hours in, he made one response to one question along the lines of, "Are you do you pray to God because you killed that boy?" or something along those lines? And he said yes. And they used that in his murder trial as the centerpiece of the case, that he praised to God because he killed that boy, or however the question was phrased. And the Supreme Court, it got thrown out by a lower court where they said the police should have been pretty clear that he was invoking his rights by implication because he didn't answer their questions for the first 3 hours. What they're basically saying is you need to affirmatively say, I'm invoking my right to remain silent. I'm invoking my right to a lawyer, which is what you should have been doing. He should have been doing in the first place. So this is only going to affect a small subset of cases where a defendant doesn't invoke their rights, but lawyers later argue that they had implicitly invoked their rights under Miranda. And I think that's what the Supreme Court was saying you can't do anymore. You're going to have to show that your guy invoked his or her rights clearly to the police, which you should do. If you're ever pulled over by the police, you look right at them and say, right into the camera, I'm invoking my right to remain silent. I'm invoking my Sixth Amendment right to counsel. I'm not going to answer any questions today. Thank you. Once you've done that, we're right back to where we were before that decision.
Mm-hmm. Okay, maybe when you talk about wills and estates, could you talk about Medicaid trusts and how effective they are now since Bush changed the look-back period?
Yeah, I will, and we'll let Mark also comment on that. And the short answer is, the look-back period is much longer now.
Mm-hmm. What is it, 5 years?
5 years.
You actually apply for it?
Yeah.
Okay.
And so I tell people you got to do your estate planning, sooner rather than later. The problem is, of course, you have to tie up assets, and that's usually what causes people to hesitate.
Okay, well, thank you very much, Carl.
All right, hey, thank you for calling.
Good day.
540-0580. Let's see here. I take one more. I got to go to break. Shane says I got to go to break. All right, 540-0580. So you have to break. Hey, welcome back. Carl Rominger here. 540-0580. Call in if you have a question, and we'll talk to you here on the air. Let's see here. Who's next? Melody, you're on WHP 580.
Hi, Carl. Thank you so much for your time.
No problem. Thank you for calling.
I have a question on my will.
Yes.
My husband and I had our wills written out. It's my second marriage. I have a adult daughter by my first marriage and no children with the second husband.
Okay.
Now that I get thinking about my will, our wills were written that we leave each other everything, and then everything goes to my daughter after whichever one of us dies last.
Right.
Well, now I'm thinking what happens to what I have for my daughter if I die first and my husband remarries.
Well, that's right. It wouldn't go to your daughter. It would go to your husband, and if he remarries, he could give it to anybody he wants.
Okay, so what do I do to protect my daughter?
What you would usually do, is you would write your will to give everything to your daughter or certain things to your daughter, but your spouse can still take against your will, meaning that they can take, I think, about 1/3 of the estate if they opted to. So anyhow, you just write your husband out and put your daughter in.
But then she would own it with him?
No, she would get whatever belongs to you out of the estate.
But if we have rental properties.
Mm-hmm. If they're jointly titled, right of survivorship, they go to him.
Even if my will.
That's
so
correct.
That happens. To my daughter.
That happens at your death. So your will doesn't affect that. The way your property's titled affects how it flows, not your will initially.
Okay, so how can I have it so that
you got to trust him, I guess, right? You got to, I guess, on speaking terms.
Well, yes, but when I mentioned this to him, he didn't say, "Well, I would make sure she got your half." So that left me uncomfortable with the fact that should he remarry, she wouldn't get my half.
Right. Well, yeah, I mean, that's the issue. What you'd want to do is divvy up the properties between you and then leave it through your estate, or actually start a planned gifting to your daughter now. But you have to get your husband's cooperation on that.
Okay, so there's nothing I can do on the will to transfer it.
Well, no, because if you and I own a piece of property together, as tenants together with right of survivorship, and one of us dies, then the other one owns it. So the will has no say.
Then should I change how it's titled?
That's right. If that's what you would need to do to get it to your estate.
And then do I have to pay a transfer tax when I do that?
Not if it's done once a year or less, and it's a transfer from a relative to a relative, or from yourself to yourself, or from you and your husband to you and your husband in different form.
And how should I title it then if I want to start changing these now?
I would do it as tenants in common, but there's other implications for that as well. So this is something you're really going to need to sit down with someone like me off the air and go through, because there's you're bringing up a lot of different issues that we'd have to discuss to figure out what's the best way to protect you. Because once you remove them from tenants in the entirety, you lose certain other protections. So we really have to be careful how we do this.
Okay.
All right?
Okay, thank you very much, Carl.
Thank you.
You're welcome.
540-0580. We got Mark Virginus here. Mark, are you with us?
Yes, I am. Thanks. Good weekend to you, Carl.
Hey, man, and I told everybody already, you're going to stay with us through the bonus podcast hour here, and you and I are going to go through some estate planning topics.
That sounds good.
And you want to just hold tight while I take a few more callers here?
Go ahead, and I'll chime in if you want me to.
All right, brother. Let's see. Neil, you're on WHP 580 with Carl Rominger. Hey, Neil.
Hello, hi. Can I ask you a question about employment law?
Yeah.
Okay, I have a situation. A couple of weeks ago, I went on a first interview, and after the interview, I never filled out an application, but I offered my resume, and after the interview, I sent references to be checked. Anyway, I had a second interview on Tuesday of this week, and at the interview, they made me an offer. They asked me to start on Monday, meaning this coming Monday at 8:30. We shook hands. When I got out to my car, I actually had received a phone call from another person I had been interviewing with a job offer, and I told them that I had accepted another offer. Anyway, I got a call on Friday rescinding the offer that was made at the interview.
Mm-hmm.
She said that she had checked some references, and it seems the information on my resume was, she said, incomplete or misleading. So I didn't get much more than that out of her. But I'm wondering, obviously I've turned down another job in the meantime, so I feel like there was some detrimental reliance on the promise of the offer. I don't know if I have any damages from that.
Yeah, because Pennsylvania's a work at will state, and I could fire you 15 minutes after you started work. It probably doesn't matter if I fired you 15 minutes before you started work. Does that make sense?
Okay. I mean, it doesn't, but I understand what you're saying. I have the legal ground for collecting damages on that.
Right.
Okay, the other thing is, she didn't get specific, but I looked up the Fair Credit Reporting Act, which apparently covers employment as well as lending decisions.
Right.
And it looks to me that she's under an obligation to disclose exactly what was told to her by whom, if that was used as a reason for my as a determining factor for my not getting the job. So I'm assuming I have the right to ask her. Should that be in writing, or should that be over the phone?
I would make a written demand, and I'm not sure. I did not know that the Fair Debt Collections Practice Act would apply to that. But do me a favor. Could you post that as a question on weekendappointment.com?
Weekendappointment.com, okay.
Post a question on there. I want to look that up, and I'll get you an answer.
Okay.
All right?
All right, thank you. Oh, and are you aware of any statute of limitations on this? I mean, is there a period in which I have to act?
Well, I got the shortest statute of limitations I'm aware of these days is 6 months. So if this just happened, you got a few months to figure it out.
Okay.
All right?
Okay, very good. Thank you.
Thank you. 540-0580. Just want to remind you folks, will and estate type questions, keep calling at 3 o'clock when we go off the air, and you'll still be able to listen to WHP, whatever great show they're going to be playing for you, because I won't be on the air. But you'll be able to call in here to the studio, and we're going to make a bonus podcast that'll show up for the next hour. And Mark Virginus, our financial guru, is going to be available as well. So if you got a financial estate type question, just a general financial question, but if wills and estate type issues, estate planning, Medicaid, Medicare, trusts, things like that, wills, living wills, powers of attorneys, 540-0580 in the 3 o'clock hour, and we'll put you on the podcast with me and Mark. John, you're on WHP 580.
Hi, Carl. How are you?
Good. How are you?
Good. I was fortunate enough to hear you and Bob talking yesterday on the immigration question. I think you two are very interesting, the discussions you have. Why, I'll make this rather fast. I do have a question in a way here. I think the vast majority, I call them undocumented workers. I think that's a much better title for them. I think the vast majority of immigrants, undocumented workers, are hardworking people who are just trying to support their families and support themselves under very difficult and even poverty circumstances. And I personally think that the road to citizenship should be made easier for most of them. Now, for the very, very few, from what I understand you said, and that commit crimes, maybe that's different. But I don't think the vast majority of them do commit crimes. I think they're hardworking people that are trying to do what I said.
Statistically, here comes music, John.
Yeah.
All right, bonus hour here, folks. 540-0580. You can keep calling in. 540-0580. Keep calling in. Mark Virginis and I will be answering your estate and legal questions and your financial and estate questions. And the phone lines are going to stay open here for almost an hour. 540-0580.